Hi, everyone, and welcome to this month's webinar, 2022 Mid-Year Employment Law Update, the Social Justice Effect. This free webinar is available exclusively for our customers enrolled in our subscription services. I'm Rosie Merlon, the researcher for Personnel Concepts, and I'm joined by my co-moderator, Leon Frierson, who serves as our senior regulatory researcher.
Hello and good afternoon to all of our attendees. I'd like to welcome attorney Kevin King as our featured guest speaker. Kevin King is a licensed attorney in New York focused on labor, employment, and entertainment law. And Kevin works closely with small businesses in all aspects of the business life cycle, including business information, COVID-19, OSHA guidance, harassment claims, severance negotiations, and non-compete reviews. Kevin also works closely with the talent agencies and influencers to develop and negotiate brand endorsement agreements. Kevin is the creator of the Influencer Almanac, a how-to guide to navigate influencer contracts.
Yes, thank you so much for having me, Leon and Rosie, and thank you for the introduction. As Leon said, I'm a labor and employment attorney based in New York. I work with businesses across the country, though, on all types of areas of law, ranging from employment to entertainment law. So, this webinar is really going to run through the new developments in 2022 for employment law. There are going to be developments in COVID-19, in OSHA regulations, and things like that. We're going to go over some of the most significant changes and then also some state changes. I think Leon and Rosie are experts in this field and they can help your business address any needs, any changes your business may need to make. So I look forward to working with them both and answering all your questions, and hopefully we cover everything that you guys are looking for.
Yeah, thank you, Kevin. And we're definitely looking forward to discussing these topics with you. And before we proceed, we want to ensure everyone can hear and see Kevin clearly. If you have any audio issues, please check the volume on your computer or mobile device. If that doesn't solve the issue, please let us know in the chat and we'll work to improve the audio as best as we can. Now let's go ahead and take a look at today's agenda.
Yes, as Kevin mentioned, today's agenda focuses on providing an overview of the various legislative action and employment law initiatives that have had the greatest impact on U.S. employers thus far in 2022. We'll start off with the most pressing social justice issues currently impacting workplaces and the published guidance released for employer consideration. Next, we'll cover significant equal employment opportunity developments, including sexual orientation and gender identity inclusion efforts, changes to the Americans with Disabilities Act implementation, and religious-based exemptions to COVID-19 prevention measures. Following, we'll review newly enacted employment laws that promote worker safety and rights, ranging from new employer obligations under OSHA and wage and hour developments to specific updates from the National Labor Relations Board and the expansion of immigration worker rights and opportunities. And lastly, we'll briefly discuss the notable state-specific employment laws that require action on the employer's behalf. The webinar will conclude with Kevin providing the best tips for employers and answering questions from our audience. And then the format for today's webinar features a series of questions that we'll be asking to Kevin regarding critical employment law updates that have taken place thus far in 2022. The purpose of this webinar is to provide accurate and authoritative information on the subject matter herein. It does not constitute legal advice. So the applicability of the laws discussed today may depend on your state, type of business, and the number of employees. We recommend working directly with legal counsel on specific matters of employment laws affecting your business. Personal Concepts, our web host, and our guest speaker are not liable for any errors, omissions, or changes in the laws. That does happen often. And Rosie, I understand you want to start us off with a poll.
Yes, let's go ahead and kickstart the webinar with our first poll of the webinar. So, which pressing social justice issues have affected your workplace culture or policies? Please go ahead and choose all that apply. We have reproductive healthcare rights, inflation for wages, work from home requests, etc., sexual orientation and gender identity rights, COVID-19 accommodations and exemptions, or is there another social justice issue that is not listed on here? And we'll give everyone a moment to respond. So votes are definitely trickling in. Okay, so it looks like most of our votes are in. So let's go ahead and close the poll and share our, oh, we have a couple more people voting. All right, so let's go ahead and close the poll and share results here. Okay, so it looks like our top two are inflation, COVID-19 accommodations. Those are definitely two hot topics, and we'll try to spend more time addressing that. And some sexual orientation and gender identity rights, and reproductive health care rights as well.
All right, and before we begin formally, Personal Concepts is offering all of our attendees our 2022 Mid-Year Employment Law Update White Paper, along with today's slide presentation equipped for note-taking, which is attached as a handout right here in GoToWebinar. Then at the end of the session, you'll receive a downloadable certificate via email as proof of your attendance today. Also, I want to invite everyone in attendance to submit any question you may have during the presentation by using the Ask Question feature in GoToWebinar. I can already see a couple actually coming through. You can also post questions in the question window, and most questions will be saved for the end of today's session, but those that are relevant to the subtopic being discussed will be posed where appropriate. And at the end of the session, you'll have an opportunity to use the raise hand feature in GoToWebinar to pose a question directly to our guest speaker. Now with that, let's go ahead, excuse me, and get started with today's presentation, Rosie.
All right, so Kevin, in recent months and years, there has been no shortage of social justice issues in the United States, many affecting employers. Few have been as impactful as the overturning of. Can you provide some insight into how the Supreme Court ruling currently affects workplaces?
Yeah, absolutely. So obviously, it's the elephant in the room. Everybody is aware that Roe v. Wade was overturned by the, Supreme Court of the United States. In short, right, Roe v. Wade provided constitutional protection for the right to abortion. So now that that's overturned, that's going to be up to the states. A lot of different departments and agencies are kind of scrambling to address this kind of, massive change. So recently, the Department of Health and Human Services released privacy guidelines to clarify how to protect patient information related to HIPAA and certain guidelines and protections related to HIPAA. So some of the key takeaways from these guidelines that were released are that healthcare providers are not permitted to disclose patient health information unless faced with a court order. In the absence of a court order, federal privacy rules about sharing health information, like whether a person obtained an abortion, is not permitted disclosure. And data collected by third-party applications. So, think about, apps that track health and fitness, period trackers, things like that. That's not going to be considered protected health information under federal rules and can be shared with other entities. So that's something to keep in mind. It's also important to note that providers may be forced to share certain information in states that may require such reporting. So this is going to be very state specific, but employers in states with reporting requirements should be mindful of the new recent change in law and be cognizant of state law changes that may come in the next few months. So in addition to these health these health and HIPAA changes, we've also seen implications on how employers provide health coverage to related travel expenses and procedures. So right now, there are about 22 states that have laws preventing or severely restricting access to abortion. As a result, several employers are expected to revisit benefits to help employees access abortion and cover travel expenses and other expenses to states where they can legally receive such services. Some of the bigger companies that are announced doing this were Amazon, I believe, Google, some of the largest companies in the country. But they've already announced these plans to kind of provide these services. I would recommend, if you're an employer, you're a small employer, you should examine your health and benefits coverage to see what's covered and decide if you'd like to make those changes. For organizations that offer nationwide coverage options, the lift is going to be a little bit less than if you currently have a narrow network reserved to one state. But it's definitely something that you might want to pay attention to, especially as the need arises and these laws continue to evolve.
Yes, and thanks for that timely guidance, Kevin. And another recent concern impacting U.S. citizens at large is the prevalence of inflation. In fact, that was backed up by our poll results. Have there been any recent legislative movements with specific implications for employers?
Yeah, absolutely. So, everybody is aware that inflation is running. I think it was announced today, right? That we're in the second quarter. We're now officially in a recession, and that's directly related to this inflation. So there are a lot of concerns. I obviously saw the poll. Recently, the IRS modified its notice that set mileage rates for 2022. So this is for reimbursement for employees that are driving to and from work and things like that. So this notice provides optional standard mileage rates for computing the deductible cost of operating an automobile for a business, for medical purposes, or for moving expenses. The IRS mileage rate also determines the reimbursed amount for those related expenses. So basically, we're seeing a couple of departments and agencies kind of make changes to certain rates. Earlier, the IRS made inflation adjustments to contribution limits for health savings accounts, and we're probably going to continue to see that. So basically, the changes are transportation expenses incurred on or after July 1st are going to have new mileage rates. What that will look like is from January 1st to June 30th, 2022, the rate was 58.5 cents per mile for business use. That is going to now increase to 62.5 cents per mile. That's from July 1st to December 31st is the new rate. For medical care and moving active duty members of the armed forces, the reimbursement rate was 18 cents a mile. That's now being increased to 22 cents per mile. And then related charitable contributions are actually going to stay the same. So the reimbursement rate will stay even at 14 cents per mile.
All right, and thanks to that up to the minute news, didn't realize we are officially in a recession. So I don't know if that's a good thing to hear or not. But to our audience, it's important for employers to watch for more reproductive health care and inflation relief guidance that may be released in response to those pressing issues. So I encourage everyone in attendance to follow our blog at blog.personalconcepts.com for to the up. We do stay on top of that. And with that, let's do another quick poll for our listeners. Rosie?
Yes, okay, let's go ahead and do our second poll. Does your company recognize the HIPAA privacy rule implications caused by the overturning of Roe versus Wade? So this is just going back a little bit toward that topic that Kevin was discussing a moment ago. Please go ahead and select one. Yes, no, not sure. Our company or state is not affected by the Supreme Court decision. And we'll give everyone a couple more moments to get their votes in. Okay, so let's go ahead and close the poll and share our results. Okay, so let's see here. Not sure. Okay, so this is good to know because this definitely helps us know what to focus on as far as the content that we put out in today's presentation. Or our company or state is not affected by the Supreme Court decision. So that's the second most chosen answer on here.
Yes, yes, and just like I said, make sure to check out our blog.personalconcepts.com. We do have an article specifically discussing the HIPAA privacy rule implications. Now, Kevin, in addition to the topical social justice issues already discussed, sexual orientation and gender identity equality rights for employees have consistently been an issue for employers over the last several years. Have any significant developments in this area happened in the first half of 2022?
Yeah, so we are seeing some developments in this area. Most recently, I think it was June 27th, which was, in Gay Pride Month, the EEOC announced that they recently revised its discrimination intake process to reflect non-binary individuals. So basically, what they did was for their intake process, they've kind of implemented the opportunity to select an X for non-binary individuals. So this is pretty significant, and it's a more of a move toward being more inclusive. Basically, they're promoting inclusion for the LGBTQI community, and kind of delivering on a public commitment that was made during Transgender Day and Visibility in March of 2022. So kind of the nuts and bolts of the change, basically the EEOC has added an option to select non-binary X gender marking during two critical stages of the intake and charge filing process. Specifically, the EEOC has updated the voluntary demographic questions related to gender in the online public portal that members of the public use for inquiries about the charge of discrimination, as well as online Spanish initial consultation form and pre-charge inquiry form that are sometimes used in lieu of the portal. So, I think we're going to continue to see changes like this that are subtle but very meaningful, especially for people that are identified, as non-binary.
All right, thank you, Kevin, for that update. And as you've expressed, the EOC constantly evaluates its policies and guidance to ensure equality for all workers. What other updates have taken place to increase rights for underrepresented communities?
Yeah, so we're continuing to see things that are affecting the EEOC. On April 5th, the Department of Justice kind of released guidance reminding employers that workers with opioid use disorder or OUD who are in treatment for recovery are protected from employment discrimination under the Americans with Disabilities Act. So the ADA is kind of handled with the EEOC. EEOC enforces the ADA. So this is all related to, the EEOC, but basically, as a recap, right, the ADA prohibits businesses with at least 15 employees from discriminating against workers with disabilities and requires employers to explore reasonable accommodations that would help covered workers perform the essential functions of the job. This new guidance is a part of the department's comprehensive response to the opioid crisis, which promotes prevention, enforcement, and treatment. It confirms that OUD is a disability under the ADA and that employers may need to make specific accommodations for employees that suffer from this disability. I think the guidance, is really focused on reducing the stigma surrounding OUD. It's obviously an issue that's been pretty prevalent in the United States over the last 15 years, and this is kind of taking aim at this stigma and making sure that employees who are suffering from this issue, can be protected under the ADA. I do want to note, right, that the guidance does not, offer protections, and it actually specifically states that it does not offer protections to employees who are, coming in to work under the influence of an opioid or really any substance, or that is violating a workplace policy that is uniformly enforced. So this is really for working with employees who are suffering from this disability and they may need accommodations, but it doesn't protect employees who are, coming in and are impaired while working on the job.
Right, right. And in addition to OUD, employers in general should be conditioned to recognize long COVID as a disability as well under the ADA. But outside of disability accommodations, what recent COVID-19 related legislation is still essential for employers to consider?
Yeah, so I'm sure that many of you have seen there have been a spike in COVID cases and infections throughout the country most recently, requiring employers to revisit COVID company policies and guidelines. There have been a couple of developments in relation to COVID-19, and I think we're going to continue to see developments probably on a monthly basis. So let me just run through a couple of them. Recently, the Department of Labor in February of 2022 released a frequently asked questions, or an FAQ, in partnership with Health and Human Services, clarifying group health coverage, plan coverage for over-the-counter COVID-19 tests. So kind of specifically, the FAQ addresses flexibility in how plans provide access to over-the-counter COVID-19 tests under previously established requirements. The guideline outlines a safe harbor for non-enforcement policy for limiting over-the-counter at-home COVID-19 test reimbursements. As such, the reimbursements may be up to $12 per test, or the actual cost of the test, whichever is going to be less. So that's something just to take note. And then in addition, in March 1st of 2022, the EEOC once again revised its guidance and answers regarding the ongoing COVID pandemic's interaction with anti-discrimination laws, which addresses Title VII of religious objections to COVID-19 vaccine mandate. So basically what this guidance by the EEOC states is that employers may ask for an explanation on how an employee's religious beliefs, practices, or observances conflict with the employer's COVID-19 vaccination requirement, that employers must continue to make the determinations on a case-by-case basis and assess individual credibility when deciding whether to grant a reasonable accommodation. Employers should assess undue hardship on the business when considering a religious exemption accommodation. Employers are warned against relying on speculative or hypothetical hardship when faced with an employee's religious objection, and employers should carefully analyze the undue hardship on the business using objective, factual, specific factors. So this really falls in line similar to the OUD ADA kind of interaction, right? We're all talking about reasonable accommodations. Basically, this is outlining, kind of directives for how employers should be navigating religious accommodations. And just to kind of continue this COVID-19 workplace policy changes, on July 12th, 2022, the EEOC updated its technical assistance for questions and answers on how to clarifying how employers should address COVID-19 related scenarios under the ADA and the Rehab Act of 1973. So basically, the July 12th updates allow employers to require COVID-19 screening and testing in specific instances. The updated guidance on COVID-19 in the workplace now conditions viral screening tests on job relevancy, necessity, and the state of the pandemic, right? So these are things that could be in flux in the coming months or years even. This limits how much personal medical information employers can obtain from applicants and employees. The updates are going to be consistent with the Americans with Disabilities Act and anti-discrimination laws as well. Under the ADA, a covered entity may require a medical examination like COVID-19 screening tests only if it is job related and consistent with business necessity. So additionally, the EEOC guidance covers applicant screening, job withdrawals, or reasonable accommodations related to COVID-19 in the workplace. So, these are all things to keep an eye on. I know people are concerned about COVID-19 compliance, and some of these changes, I think, might be here to stay. So it's important to pay attention to these.
Yeah, thank you, Kevin. And in addition to the workplace safety issues stemming from COVID-19 protections, there have been a few significant developments in workplace illness response brought forward by the Occupational Safety and Health Administration, also known as OSHA. Kevin, can you go over OSHA's new heat-related illness program requirement?
Yeah, absolutely. I think this is, all related to this current administration, the Biden administration's kind of directive to, focus on employee rights and employee protections. So in April 8th of 2022, OSHA issued a national emphasis program on indoor and outdoor heat-related hazards. This basically expands the agency's ongoing heat-related illness prevention campaign. The NEP, or National Emphasis Program, took effect on April 8th. So now it's currently in effect, and it will remain in effect for 3 years unless canceled or superseded by another directive. It applies to all industries, general industry, construction, maritime, and agriculture are all included, but it's going to specifically target industries exposed to heat-related hazards such as construction sites, automobile factories, petroleum refineries, chemical factories, glass factories, iron and steel mills, in some instances, bakeries, cattle ranches, farms, some nursing facilities, things like that. So just to get into kind of more detail here, this national emphasis program is going to apply when employees are exposed to outdoor heat at or above 80 degrees with the humidity at or above 40%. And specifically, this is not going to apply to incidental exposure, which exists when an employee is not required to perform a work activity outdoors for more than 15 minutes in any 60-minute period. So for instance, if you own a restaurant and you have somebody taking out the garbage and it's a 100-degree day, that's not really going to qualify under this. Some more detail I'd like to just go into here on how this is going to kind of be implemented. So OSHA will conduct programmed inspections when the National Weather Service has announced a heat warning or advisory in the area. An unprogrammed heat inspection occurs if a hazardous heat condition is recorded in an employer's OSHA 300 log or 301 incident report, or if an employee raises a heat-related issue to a compliance officer. During all inspections, OSHA inspectors must also ask employers about their heat-related prevention programs, what they have in place and things like that. OSHA is also going to do a follow-up inspection when an employer is cited for a heat-related fatality to determine whether abatement was implemented. What OSHA is basically going to be looking for in these inspections, they're probably going to be looking for whether your company provides accessible, cool drinking water to employees at all times and at no cost to them, that you have a written heat illness and injury programs and train employees on hydration, heat illness signs, first aid, and summoning emergency personnel, that you guys are monitoring abatement temperatures and levels of work exertion at work sites, that you're scheduling rest and hydration breaks, that you're providing access to shaded areas, that you have job rotations in the event you have employees working in the heat, or if you have a buddy system. So all of these things, if you are in this industry, hopefully, you're already up on this, but, if you need to revisit it, definitely take a look at this guidance, speak with Leon and Rosie as well, and they can help you with this stuff.
Yes, yes, and it sounds like someone's trying to alert OSHA in your background, Kevin. Our audience, please do not be alarmed. He's in the New York City area, so I'm sure it happens all the time. And that breakdown should be very useful for our audience, specifically those in the before mentioned targeted industries, as far as heat, illness in the workplace. But additionally, OSHA has proposed changes to the injury and illness reporting requirements. Can you go over some of the specifics of that proposal?
Yeah, absolutely, Leon, and you're spot on. I'm sorry about that. There's some traffic outside my window. But basically, OSHA is proposing more OSHA updates, amendments to occupational injury and illness record keeping regulation. So currently, the regulation requires certain employers to electronically submit injury and illness information that they are required to keep to OSHA. The agency uses these reports to identify and respond to emerging hazards and make aspects of the information publicly available. So in addition to reporting their annual summary of work-related injuries and illnesses, the proposed rule would require certain establishments in specific high-hazard industries to electronically submit additional information from their log of work-related injuries and illnesses, as well as other injury and illness incident reports. So this new proposal requires establishments or companies with 100 or more employees in specific high hazard industries to electronically submit information from their OSHA forms 300, 301, and 300A to OSHA once a year. It also requires them to update the classification system used to determine the list of industries covered by the electronic submission request. Another update would be to, or proposal would be to remove the current requirement for establishments with 250 or more employees not in a designated industry to electronically submit information from their Form 300A to OSHA annually. And then in addition, it will require establishments to include their company name when making electronic submissions to OSHA. Establishments with 20 or more employees in certain high hazard industries would continue to be required to electronically submit information from their OSHA Form 300A annual summary to OSHA. So, if you fall into this category, again, OSHA, this is very, very nuanced, but it's something that you really want to pay attention to.
Yes, and before we move over to the worker rights segment of today's presentation, Personal Concepts would like to understand how further we can assist your OSHA compliance efforts. And so we have our third poll of today's webinar. What OSHA compliance resources are you most interested in? Please go ahead and choose all that apply. Required workplace posters, required OSHA training programs, customizable OSHA policy templates, OSHA handouts and best practices posters, or is there another resource that is not listed on here that you may be interested in? We'll give everyone a couple moments to respond. Votes are trickling in. Okay, and looks like most of our votes are in. So let's go ahead and share results. Okay, so it looks like the majority of you are interested in required OSHA training programs, followed fairly closely by required workplace posters, customizable OSHA policy templates, and OSHA handouts.
Yes, great information there, and just encourage everyone to definitely check out your digital workplace compliance library. We do have tons of OSHA guidance and resources there for all of you, and you're all subscribers, so you should have some type of access. If not, just contact our customer service, and we'll help you out with that. Now, a major focus of the current administration's worker rights initiatives is centered around wage and hour enforcement. Kevin, can you give us a breakdown of the changes to retaliation enforcement under the Fair Labor Standards?
Yeah, absolutely. So on March 10th, 2022, the Wage and Hour Division of the United States Department of Labor published a field assistance bulletin. So this is similar to guidance or an FAQ, and it was entitled "Protecting Workers from Retaliation." Basically, this guidance provides information on anti-retaliation protections available under the Fair Labor Standards Act. And just as a recap, right, Fair Labor Standards Act is going to be directly related to what you pay your hourly workers and things like that. Basically, this FAB or Field Assistance Bulletin details prohibitions against retaliations, under various laws enforced by the Wage and Hour Division, which I think they're up on your screen right now. Some of these specific examples of prohibited retaliation include termination, and you know, some of these things are going to be obvious, but it's important to run through them, right? Termination, confiscating a worker's passport or other immigration documents, taking some sort of disciplinary action against an employee who's raising a concern over an FLSA violation or alleged violation, threats to employees, their families, or coworkers, reduction of work hours or rate of pay, shift changes or elimination of premium pay, blacklisting somebody from a certain industry, demoting them, or excluding an employee from a regularly scheduled meeting. So, you know, all of these things, I think they go without saying that, you know, you shouldn't be doing this. But, you know, these are specific anti-retaliation statements that have been put out in related to the FLSA. So you just want to make sure you're not taking any of those actions.
Yes, thank you, Kevin. And in addition to the retaliation protections, the Biden administration also ended the back and forth on tip pooling for tipped employees. Can you provide details on how employers must address tip pooling regulations moving forward?
Yeah, definitely. So, like I think I mentioned earlier, right, this Biden administration has really been emphasizing employee rights. So basically, they initially delayed the implementation of the Trump administration's tip credit rule, but then kind of engaged in a separate rulemaking process, ultimately leading to new tip credit regulations. These regulations went into effect right at the start of the year, right at the end of last year, and effectively they reinstate the 80/20 rule, but impose even more restrictions on employers seeking to take a tip credit. So kind of some of the changes here. Now under federal law, employers can only take a tip credit for the time tipped employees spend performing work that produces tips, which is providing services to customers, such as a restaurant, working in a restaurant, taking orders from guests and serving them food and beverages, or directly supports tip producing work, like preparing for or otherwise assisting customer service work, such as servers, rolling silverware, folding napkins, setting tables. It may also include downtime waiting for a person to perform customer service. So kind of critically here, employers can no longer take a tip credit if an employee performs directly supporting work for a substantial amount of time. In other words, no tip credit can be taken for directly supporting work that exceeds 20% of an employee's weekly hours paid at a tip credit rate or 30 continuous minutes. So, you know, this is a little bit of a nuanced area. If you work in the restaurant business or another area where there are tips, you know, I really hope that you guys are staying up on this. And like I said, you know, always reach out to Leon and Rosie as well for further guidance.
Yes, yes, and thank you for reminding our audience of those obligations to tipped employees. And similarly, the Biden administration overturned a Trump era decision on the misclassification of workers. Can you review the details of that NLRB memorandum?
Yeah, absolutely. So, you know, I can't say it enough, right? It's just a back and forth between the administrations. But on March 17th, 2022, basically the National Labor Relations Board's general counsel, they issued a complaint seeking to overturn a Trump era decision holding that misclassifying employees as an independent contractor is not a standalone unfair labor practice. So it's just some background here. The NLRB general counsel issued a complaint against a couple of trucking companies, warehouse and logistic companies that are based in California, and basically alleging their misclassification of drivers for their companies as independent contractors rather than employees violated the National Labor Relations Act. So kind of some details about the complaint. Basically, the complaint alleges that the misclassification of drivers prevented them from engaging in concerted activity protected under the NLRA. Just some more background here. Independent contractors are not considered employees under the NLRA and thus are not afforded protection of the law, including the right to form a union. You know, in addition, independent contractors generally do not have other NLRA legal protections such as workers' comp and unemployment insurance. So it is pretty significant here, right, if a company is classifying somebody as an independent contractor versus an employee. So the case is called Velox Express, and it was a 2019 case. The Trump era NLRB found that misclassifying employees in and of itself does not constitute a violation of the National Labor Relations Act. So right now, right, this new case, this new complaint being brought by the general counsel is looking to overturn that and basically saying, you know, this is a cause of action in and of itself, and that these employees should be paid consequential damages suffered because of their misclassification, in addition to other remedies. So it's definitely something to pay attention to. We'll see what the outcome is, but seeing the direction of this administration, I could see it going in the general counsel's favor. Just some other updates here from the NLRB. There are also some memos and complaints out in relation to captive audience meetings. I'll spare you some of the details here because it might not apply to a lot of you. But basically, the general counsel for the NLRB is looking to make captive audience meetings, which are meetings that employers hold with their employees to kind of discuss union activity and things of that nature. They're basically trying to pass regulations that say that captive audience meetings should be voluntary. Right now, some states make them involuntary, meaning make them mandatory that you have to show up to them no matter what. This memo from the NLRB General Counsel is basically trying to argue that they should be voluntary. So we'll see how that turns out as well.
Yes, yes, and thank you for reviewing those crucial worker rights initiatives. Coming up, we'll cover additional guidance from the National Labor Relations Board and other agencies that address immigrant worker compliance. But first, we have a poll for our audience. Rosie, if you can engage them.
Yes, and regarding this, what is your company's relationship with immigrant workers? Please go ahead and choose all that apply. We hire high-skilled immigrant employees. Sorry for the typo there. We hire low-skilled immigrant laborers. We hire low-skilled immigrant call center admin staff. We do not currently staff immigrant employees, or we neither seek out nor discriminate against immigrants. Okay, so we'll give everyone, again, a couple moments to just get their votes in so we can get a better understanding of our subscriber base. Okay, it looks like a couple more votes are still trickling in. So we'll leave this open for just a couple more moments here. Okay, let's go ahead and share our results. Okay, so the bulk of you neither seek out nor discriminate against immigrants, and looks like that's followed by we do not currently staff immigrant employees.
All right, and I'll go ahead and take credit for that snafu. We high skilled employers. Yes, definitely we hire. You're correct about that. Thanks, Rosie. And it looks like not too many people hire immigrants. So I definitely share the information with this, Kevin. But we can kind of get through this section a little bit quicker and make sure we have enough time for questions at the end. So research tells us though that the NLRA took strides to improve work conditions for immigrant workers earlier in 2022. Can you provide our audience with some insight into those efforts, please?
Yeah, absolutely. I see a lot of the companies that we're presenting to today don't have immigrant workers. I think it's still important just to kind of keep everybody updated on some of these changes. Basically, the NLRB General Counsel issued a memo reiterating the rights of immigrant workers under the National Labor Relations Act. And this is kind of continuing its aggressive approach to expanding legal protections to workers and labor unions. So they issued a memo, 2209. It basically reestablishes NLRB policies on workers' rights to access NLRB collective bargaining and remedial procedures, regardless of immigration status, and without fear of reprisal from the employers of the federal government. Basically, this new memo covers the following rights of employees seeking assistance against immigrant worker exploitation. So this guidance, it basically issued a fact sheet that the NLRB agents will provide to witnesses during investigations. This fact sheet will explain how immigration status is not relevant to whether the NLRA has been violated. It offers a guarantee that information obtained during the NLRB investigations is protected, and the charging party or witness have a right to ask the board to seek immigration relief if it is necessary to protect employees participating in NLRB processes or exercising their rights under the NLRA. So just something to, I saw there were a couple of, votes for that you hire immigrant workers, just something to pay attention to in the event you're in a union environment or something like that.
Yes, thank you, Kevin. And outside of the protections established by the National Labor Relations Board, were there any other essential updates for immigrant workers?
Yeah, this one kind of more relates to the job market and some foreign laborers, but basically the Department of Homeland Security announced in May the availability of about 35,000 more H-2B temporary non-agricultural worker visas during the second half of the fiscal year 2022. So that's basically from the range of April 1st, 2022 through September 30th, 2022. Basically, so if you're a company out there that you're employing immigrant workers and you use this type of visa, you kind of have to prove that there is a need for this employee, that hiring this employee who is coming over on a visa wouldn't disrupt current labor markets, and that there is no actual supply of employees who can fit this niche. So niche little section that you're looking to hire for. So it's something to pay attention to if this does affect you. And there are additional visas out there for this fiscal year. There are some additional updates actually from the Department of Homeland Security. So this relates to I-9 verifications. So many of you know that standards for in-person I-9 verifications due to COVID-19 have been relaxed over the last 2 years. Initially, it was a short-term measure introduced in March 2020, but that's kind of been extended now out until October 31st, 2022. And some people are advocating to make it permanent. It's, we'll see what happens. It keeps on getting moved. Just a recap of kind of what has been the status quo over the last 2 years. Employers with employees working remotely due to COVID-19 aren't required to review employees' identity and authorization documentation and purpose in person. This originally only applied to workplaces where everybody was remote, but the DHS has extended flexibility to employers who have both in-person and remote employees. Secondly, employers may inspect Section 2 documents remotely over video or fax or email and retain copies of the documents within 3 business days of hire. Employers should enter COVID-19 in Section 2 additional information field, and when normal operations resume, if they ever do, employees who were onboarded remotely must verify their documents in person. Employers should go back to Section 2 additional information field and add documents physically examined on the inspection date. So in the event there's any type of audit or anything with this I-9, you just want to make sure you're up to speed and in compliance.
Yes, yes, and thank you for reviewing those important updates for employers looking to hire workers from outside the United States. There were a number of you in our audience, so it's never meant to discount you all. And before we round out the presentation with state-specific legislative updates, we like to poll the audience on their methods of how they obtain local employment law news. Rosie, can you help us out with the final poll?
I sure can, Leon. All right, so what resources do you use to keep up with state, county, and city employment laws? Please go ahead and choose all that apply. Personnel concepts, white papers, blogs, webinars, etc. Government agency publications and communication. Do you have human resources personnel, private news and media outlets? Or is there another resource that is not listed on here that you get that information from? Okay, looks like we have a lot of votes coming in, so let's go ahead and leave this open for a couple more moments. Okay, so let's go ahead and close the poll and share results. Okay, so this definitely great news. Personnel concepts, white papers, blogs, and webinars. So that's definitely great. Followed by government agency publications and communication. And looks like it's human resources personnel and also private news and media outlets both got 50% right there, and 40% of you get it from another source.
Oh yeah, like you said, great news to hear. Personal Concepts is helping out somehow, some way. We appreciate your response there. Our audience is joining us from various states throughout the U.S. And given that it's just as important, in some cases more important, that they abide by and implement state-specific employment laws, can you cover some of the most impactful state-level updates from the first half of the year?
Yeah, absolutely. So, there's 50 states, right? We can't cover all of the updates, but I kind of cherry picked some that I think are interesting and may apply to some of the audience here. So for California, California Supreme Court issued an important wage and hour decision in the beginning of this year. This case, Naranjo, California, basically held that meal break premiums that an employer pays to an employee for missed, late, or short meal breaks, ugh, tongue twister there, constitute wages. So consequently, an employer must report those premium payments on an employee's wage statement pursuant to Labor Code Section 226, and pay any owed premiums when an employee is terminated, or faces waiting time penalties under Labor Code 203. So just something to pay attention to there if you're in California. And then these next two updates kind of go hand in hand. In New York State, and in addition to Washington State, there are new laws being passed and implemented that basically require employers to disclose the salary range for certain positions. This is a trend that I think we're going to see continue to grow. I think a couple other states are going to be picking this up soon too. Actually, the law that is being proposed in Washington goes even a little bit further and requires a description of all the benefits and other compensation to be offered to the hired applicant. So, if you're somebody who hires remotely, or you're working with any employees that are in these states, it's important just to be mindful that you are listing the salary range. I think New York law goes into effect November 1st, and the Washington one is proposed, but it looks like it will get passed. So, you want to make sure that you're on top of these things too.
Yes, yes, and thank you for quickly reviewing those timely updates in California, New York, and Washington. As we said, in the interest of time, we cannot cover all of the affected states, but still I'm here to remind our audience of the 2022 Mid-Year Employment Law Update White Paper that is available as a download. It features a list of all the enacted employment laws that have taken effect thus far in 2022, and that's all categorized by state. So make sure to download that before you leave today, and you may have received it by email as well. Before we move on to questions from our attendees, Kevin, do you have any final tips for employers? You know what? Just before I ask you that, I want to remind everyone, please submit your questions for our Q&A session that's going to come up just after these final tips. We do have some, but we want to make sure that any important questions are answered today. But Kevin, if you could go ahead and engage us with your final tips based on the 22 employment laws that we've covered in today's presentation.
Yeah, absolutely. A couple of kind of general tips. I think, everybody should be paying attention to the ongoing COVID-19 pandemic. I think everybody probably has done a good job staying on top of these developments, but states and localities are continuing to implement very niche rules related to, mask mandates that might pop up with COVID spikes, or, certain workplace prevention illness programs that might be in place. So I think it's really important just to kind of stay attuned to these COVID-19 developments as they arise, and pay attention to what your state or locality is kind of discussing. The second one is also related to COVID-19, and this is related to kind of what we touched on earlier, but whether inquiries for reasonable accommodations under the ADA related to COVID-19. I think it's just important for businesses to really pay attention or look out for claims for accommodations related to somebody who might have had long COVID or some sort of complication related to COVID. You have to engage in the interactive process with them just like any other accommodation. And I think that, as the pandemic continues to move on, hopefully we move away from some of these complications, but I think it's important to just kind of pay attention to any type of interactive process that may need to be had. The third thing is very general, but I would say make sure if you have an employee handbook that you're reviewing your employee handbook or your internal policies and procedures to make sure they are up to date with any recent developments. You really don't want to be put in a position where laws have changed, you're aware that they changed, but your handbook kind of suggests something that is outdated. An employee comes to you and you either have to explain it away, or you get caught up in some sort of liability or issue related to that. So, if laws are changing, and you're aware of them, make sure you're auditing your handbook, going through and paying attention to any new developments. My fourth thing, we're just keep on getting more and more general with my tips here, but document everything. I think this goes without being said, but you want to keep adequate records to ensure that you're protected, that you follow the appropriate policies and procedures, whether that's your internal policy or the applicable law, and that you made decisions based on those policies and procedures. I think just keeping things documented, making sure whether it's related to an FMLA request, which we didn't discuss today, or ADA compliance, terminations or offer letters, you really just want to make sure that you're buttoned up it goes a very long way in preventing any future liability or any type of litigation that could develop. And then my fifth recommendation is maintaining an open and accepting workplace, and where possible, including a knowledgeable and dedicated HR professional to give employees with protected characteristics and needs equal access to the workplace and to avoid any future lawsuits, right? I always preach it's better to be more inclusive, even if you're not in a state that doesn't necessarily require it. So, I would really recommend just kind of, opening up your doors if you're closed to that, and I think it could go a long way.
Absolutely, and general works for our general audience. As we serve customers across many state lines and in different industries. So those tips are very well received. So thank you, Kevin. And before we end today's session, I'd like to remind all of our attendees that you will receive a follow-up email with a certificate of proof of attendance today. And now let's take a moment to answer some of those questions from our audience that were submitted throughout the presentation. So I'll go ahead and pull up one here. And this goes back to somewhat in the beginning of our presentation where we're discussing sexual orientation and gender identity. One of our customers asked, should our business emulate the update to the EEOC discrimination intake process by adding an X gender marker to our job application forms?
Okay. Yeah, I think that's a great question. I think it goes back to my last tip, right? It doesn't hurt to open up your doors a little bit. If it's not necessarily required by your business to include, an X on the intake form, I think, you should always get ahead of the curve. In including this. Not only will it, invite more diverse candidates who might feel more comfortable applying to your job or your company, but also down the line, right? You don't have to make any drastic changes or be reactive, right? That's called being proactive, and I would strongly suggest revisiting or auditing your documents for onboarding or application process and just including it. It's a very small change, but I think it could go a long way for work culture and bringing people who are feel more comfortable if that's how they identify.
Absolutely, great guidance there. And then along the same lines as a worker being diagnosed with OUD or opioid use disorder, are similar protections available under the ADA for those who are found to abuse other legal and in some found to abuse other legal in some jurisdictions? They quote there um, drugs or substances like alcohol and marijuana. Sorry, I kind of butchered that. They had some things in quotations, but basically, are there any protections for people using legal substances but coming into work impaired?
Yeah, so it's a little bit nuanced, but I would say, right, similar to the opioid use disorder emphasis that the Biden administration has kind of shined their light on. If you have an employee who is an alcoholic or suffers from some other substance abuse and they're in rehab or they are seeking treatment, or it is affecting their ability to kind of work consistently or something like that. And I'm not talking about showing up to work, impaired yet. But if somebody is basically abusing any substance, not just opioids, that would and can be considered a disability under the Americans with Disabilities Act. And you would have to engage in an interactive process to see if a reasonable accommodation would make sense for them. And obviously, make sure it doesn't pose an undue hardship on your business. Now, same goes with what I stated with the opioid use disorder. If somebody is coming into work impaired, and they're trying to perform their job while they're under the influence of a certain drug, that's not going to be something that's protected. Termination would be warranted in certain circumstances if somebody is showing up impaired. So there is a fine line, right, of somebody who suffers from, let's say, alcoholism, but they're not coming into work drunk, but maybe they're missing a few days here and there because of that, as opposed to somebody who's showing up impaired and violating, a policy that you have or something like that. So if that answers your question, I think it's a little bit nuanced, but I think there is a fine line.
Yes, yes. Thank you for that. And we have a few questions pertaining to those most recent social justice issues. So I want to get those in really fast as this is the Social Justice Effect webinar. Uh, One customer asked, can my business be penalized for offering reproductive health care benefits if my state outlaws it?
So yeah, that is a really great question, and I think the answer is going to be, which nobody wants to hear. It will depend. There are certain states that they already have on the books that went into effect as soon as Roe v. Wade was overturned. That basically say, if you are performing an abortion within a certain state, that you could be penalized criminally. Now that whether that extends to offering healthcare services to somebody who's seeking, a treatment that's outlawed within your state will depend on what the laws are in your state as well as what your health coverage is. So it is extremely nuanced. Unfortunately, like I can't, without getting more information, and I can't give you a perfect answer. But states that might have it outlawed, or certain healthcare coverages that might not extend to the traveling expenses and things like that, it could actually be considered, you could be penalized. But I think there are ways to navigate that, and we're going to continue to see guidance come out over the next few months. So I would sit tight and just kind of pay attention to any updates.
All right, here, and I'm going to have to grill you with a couple COVID questions. They are flying in, and so we'll just try to get through these as fast as possible. I know that some of them also will be state specific, so if it is something that we need to get back with the customer with, please just let us know. First off, the Chelsea in the audience asked, the $12 reimbursement for COVID tests is being paid by the insurance provider or by the employer. I do know it does affect group health plans, but
Yeah, this should be paid by the insurance provider. Um, that's my understanding of this development. So that $12 or the test that would be less, that would be paid by the insurance provider.
right, right. And then Jennifer asked, for Illinois healthcare workers, what documentation do we need on file for employers' COVID vaccination and boosters, and what documentation do we need for those filing for an exemption?
I would have to look into Illinois' law. I believe Illinois is in line with what most states require, which is that you would need, for healthcare workers, you would need 2 shots. I don't think a booster would be required, but you can't quote me on that. I need to look into what specifically Illinois has on for what their requirements are.
Yep. So we'll make sure we get that information specifically back out to you, Jennifer. And then Daniela asked, any updates? Employee pay for COVID absences, do they have a different paid sick hour bank? 40 hours sick pay or 40 hours COVID pay? I think this might be a state issue, but you can expand on that.
Yeah, in certain states, right, there were reimbursements for COVID sick pay. Some of those states, and I believe federally, any of those programs might have run out. So I think at this time it would depend on what state you're in, but generally speaking, right, a lot. I know a lot of states and businesses now, if you are sick with COVID and you're taking sick days, that would just come straight out of your sick time. There's no separate bank at this point. But if you're in a
And
state that,
I'm sorry, she's in NY. She just clarified.
okay, she's in New York. Yeah, I don't think New York has any specific requirements where you have to give designated COVID sick time now. There's no delineation.
And then, really quick, Jennifer said, and what about the healthcare workers that want exemptions? And this was going back to the Illinois question. Is there any recommendation you can have for documents that they need to have on file?
um, that are looking for an exemption. So if their exemption is going to be related to some sort of medical concern, generally speaking, right, you would go through basically a reasonable accommodation process, right? Because if they're a healthcare worker, and I'll try and speed it up because we're ending in a minute, but basically if they're a healthcare worker and they are looking for an exemption, you would need, medical documentation provided by their doctor to explain why they're not allowed to basically get this vaccine. And you would need to make an assessment on whether, if they were operating in a health care facility without the vaccine, how that would place a hardship on your company. And then from a religious side, I think we could send you that information as well, but kind of the interactive process is the same, but you can kind of for lack of a better term, grill a little bit harder and basically say, how does this religious exemption prevent you from, getting the vaccine? That's kind of the documentation that you would be needed in terms of, getting an exemption. But I believe that Illinois would have guidance, and I can look into that for you, specifically on exemptions in the healthcare setting because that's highly regulated.
Yes, yes, and unfortunately we have run out of time. You guys did have some great questions submitted. We'll make sure to get those out to you because all unanswered questions will be forwarded to Kevin via email, and his responses will come to you all in the next upcoming days. And I want to thank everyone who submitted questions about today's topic. And Kevin, thank you for taking the time to answer them. It's much appreciated.
Thank you very much, Rosie and Leon. I really appreciate it, and thank you everybody for listening.
Thank you. And we enjoy hosting webinars for our valued customers. And as such, would appreciate your feedback. Please stick around for a few minutes as a brief survey will open up for you to rate what you saw and heard today. We hope you found this information helpful in understanding critical employment law updates taken thus far in 2022. Thank you again to Kevin for being our guest panelist. We look forward to continuing to work with Kevin on future presentations. And if you enjoyed today's webinar, we invite you to view past webinars on demand at the link provided on the screen. To all of our attendees, thank you for choosing Personnel Concepts as your provider of workplace compliance solutions. Thank you for attending our presentation, and this concludes today's webinar. We hope everyone has a great afternoon.